Good afternoon to all. A very warm welcome to LAWVS first National Moot Court Competition 2005. We are honored to have our learned judge, Advocate Avdesh Pratap Singh, in this courtroom. We welcome you, Lordship. Before starting with the argument, we would like to brief the bench about the functioning of the courtroom. I, Archit Talwar, will be serving you as court master and will be assisting you with maintaining the decorum and to assist the honorable bench. The court masters will act as a facilitators between the bench and the counsel. The court master will time the arguments and intimate the bench accordingly. Your lordships is requested to please seek our assistance whenever it is required. As stated in and rules of Law vs First National Moot Court Competition 2005, each team will get 25 minutes to present their case, including 5 minutes will be given for rebuttal and sub-rebuttal subject to the discretion of the honorable judge. Each team shall intimate the court master in regard to division of time between speakers. Only one speaker from each team shall be permitted for the rebuttal and sub-rebuttal. The order of presentation is first speaker petitioner 1, speaker 2 is petitioner 2, respondent is speaker 1 and speaker 2 is respondent 2. Rebuttal, sub-rebuttal, petitioner, any one of the two speakers can do it. Sub-rebuttal, respondent, any one of the two speakers. Where sub-rebuttals will be permitted only at the discretion of judges. The judges may exercise discretion for extending the time for the oral rounds beyond the time specified in the rule book. The rule book provides that time extension up to 2 minutes, which is permissible for each round. Team code for the petitioner is 41 and the team code for the respondent is 07. If there is any time taken for rebuttal, then it is mentioned to ask before the commencement of the round. Total time is 15 minutes. With petitioner speaker 1 presenting their side for 10 minutes and speaker 2 for 10 minutes, whereas the respondent speaker 1 presenting their arguments for 10 minutes and the speaker 2 for 10 minutes. Each of the speaker will be having 10 minutes. 5 minutes will be giving for rebuttal. I now would like to seek the permission of the bench to start with the proceeding. So can we start with the proceeding?
Yes, you can start, but I have also one question.
Yes, sir.
Will you also add the timings of the question and answer? Whatever questions I will ask to the participants, will you add those time also?
Yes, so we have added it.
Okay. So let's proceed. Start.
I now request the petitioner to start with the proceedings.
Warm greetings to the bench. Counsel seek permission to address bench as the lordship. Am I audible, sir?
Yes, you are audible. You can start with your proceedings.
If your lordships are well versed with the facts, counsel seek permission to directly move on to the arguments advance of the issues. First, let us go through the facts. The Banke Bihariji temple located in Vrindavan, Uttar Pradesh is one of the most important Krishna temples in India and a major site of pilgrimage under the Pushti Mark tradition. So this temple is annually attracts 50 lakhs pilgrims and it is located in a organically developed heritage present characterized by traditional residential structures, century-old religious institution, and small-scale commercial establishment. But despite multiple studies and administrative observations, nothing to area's vulnerability to congestion, comprehensive infrastructure changes had not been implemented prior to 2022. On August 19th, 2022, during the celebration of Janmashtami, a tragic stampede occurred during the early morning of Mangalarati. Thousands of devotees surged towards the sanctum, leading to crush inside the temple premises. The incident resulted in the deaths of 2 devotees and caused injuries to 25 others, some of whom required critical care. Initial reports attributed the tragedy to a combination of factors, including overcrowding, lack of regulated entry and exit points, insufficient personnel for crowd control, and physical constraint posed by surrounding infrastructure. Aftermath, civil society groups approached the High Court through Article 226 and filed a PIL requesting for the judicial intervention, and they prayed for development of comprehensive crowd management system, emergency medical structure, and widening access roads and certain safe entry and exit channels. State of Uttar Pradesh, in replying to this case, they proposed for a large-scale Banke Bihari Temple corridor project, which includes demolition of 300 structures, acquisition of approximately 8 acres of land, and construction of dedicated corridors, emergency exits, pilgrim holding areas, public sanitation, and medical aid centers. On 20th March 2023, Allahabad High Court issued a judgment which directed the state government to initiate the proposed corridor project. The court given the justification of public safety and public life. Following this High Court judgment, the widespread opposition of the stakeholders like residents, shopkeeper associates, environmentalists, and heritage conservation, a coalition group led by Govindas filed a special petition before the Supreme Court of India, and he urged that a project would result in the eviction of 200 families and displacement of approximately 500 business and irreversible damage to the cultural fabric of Vrindavan. And he also and the environment experts consultation have not been taken. So seeing all these issues, all these incidents and circumstances, in April 2024, Govindas and other stakeholders filed a modification application urging the court to prevent the even land acquisition until the due process was followed. Recognizing the complex interrelationship between the right to religion, right to life and environment, protection and property, and state environmental and cultural duties, the Supreme Court referred the matter to five-judge bench, and high-powered committee was also constituted to assess. If your lordships are well versed with the facts, I'll seek permission to move on to the arguments.
Yes, please.
So the issues for the consideration framed by the Supreme Court is: the first issue, whether the High Court's mandamus under Article 226 directing a particular corridor scheme amounts to impermissible micromanagement of executive policy, or is a constitutionally valid exercise to remedy a systematic failure to endangering life and safety. Whether reconfiguration of temple approaches, alleys, and religious circulation routes implication Article 25 and 26. If so correct, the test to distinguish faithful facilitation and unconstitutional interference. These two issues will be. I am dealing with these two issues. My co-counsel will deal with the issue 3 and 4, which is about the public safety and large demolition and the arbitrariness under Article 14. So let us move to the first issue, that is whether the High Court's mandamus under Article 226 directing a particular corridor scheme to amounts to impermissible micromanagement of executive policy, or is a constitutional exercise to remedy systematic failure and endangering safety and life. To realize this, we have to distinguish, we have to first realize what are all the limits in which the courts and executive should function. So to understand this, first thing we have to do is that first we have to understand what is the doctrine of separation of powers, which laid down for this limitation and which prescribes the boundaries in which executive and judiciary should function. So if you go to the origin, how this doctrine of separation emerged, we find reference of the Aristotle in his book Politics, where he explains what is this power of doctrine of separation of powers. He explains that to form a model state, one of the essential to form a model state is that there should be a separation of power. Why? There should be a separation of power because if there is no separation of power and the power is concentrated in only one hand, then it will lead to the tyranny and it will be the end of democratic state. Further, Montaigne establishes the same principle and developed it further, and a link between the arbitrariness or the people's liberty and a link between the separation of power. He says that there is no liberty if the judiciary power to be not separated from legislative and executive. He says that whenever the judges encroaches their boundaries and they step into the executive and legislature shoes, then it will violate the principle of separation of power, and it will be the end of liberty. So to ensure people's liberty and people's fundamental rights, executive and judiciary to go in hand harmoniously, and they should not encroach either each other's field. So what about this separation of powers in India, even though there is no expressed provisions about the separation of powers in Indian constitution framers incorporated the separation of powers through article 50, which says that states shall take steps to separate the judiciary from the executive in the public services of the state. The great emphasis I have given to separate the judiciary from the executive. Why it is a given? So we have to examine what is the thin line that exists between the judiciary and the executive, and crossing which line, which it amounts to the impermissible micromanagement of the policy. In the case of Golaknath of the state of Punjab, the court observed where the clash between the executive and the judiciary was there about the land reforms matters. The court held that these separate organs like legislative, executive, and judiciary, these separate organs should perform, they should function within their limits prescribed by the constitution. If they encroach these limits, if they cross these limits, then it will be the violation of separation of power, which is the part of basic structure of Indian constitution. In the case of Almatira H. Patel versus Union of India, where the case was about the municipal corporation was had the responsibility to clean the Delhi. Here, the petitions were filed the Supreme Court requesting the court to direct the municipality authority, which is the executive authority, to clean the Delhi. So in our case also, there is a petition requesting the court to direct the government to implement the authority, and the High Court did the same, directing the state to implement the project. But in this case, court refrained. It applied the principle of judicial restraint, and they restrained from applying this principle. They restrained from encroaching their limit, and it held that whatever the issues, questions which falls within the executive domain, it should not be touched by the judiciary. And the court held that judiciary is going to apply the principle of judicial restraint, and it won't do the overreach. In the present case also, the corridor project questions completely falls within the executive domain, and it should not be touched by the court, applying the principle applied in the present case. In the case of West Virginia versus Environment Protection
Mr. Counsel, I have a question.
Indeed,
You are talking about separations of power. I
Indeed,
got
Your
your point, what you want to say. But tell me the very specific or particular thing that if the state itself proposed the corridor scheme, right? It is not the judiciary or the High Court that has proposed the corridor scheme. It was the state. If you read the para number 5 and 6, how can the High Court's order to execute it be called a judicial overreach? Give me the answer.
Your Lordship, in the case of Narmada Bachao Andolan versus Union of India, the Supreme Court cleared when can a judicial intervention when a judicial should intervene in the infrastructure matters, and at the what step the intervention will amount to the valid intervention, and what step at the intervention will amount to the micromanagement of policy. Court explained that there will be 3 stages in the execution in the execution of infrastructure projects. The first plan is planning to infrastructure project. Second is that taking the decision to implement the project. Third is the execution of the project. In para number 228 of the Narmada Bachao Andolan case, the court mentioned that the first step, which is a planning stage, their court cannot intervene because it's a policy matter. Second is the taking the decision after the consultation. The third step is execution of the policy. Court held that any court or the judiciary cannot intervene at the first step or the third step, that is the planning step and the executive step. It can only intervene at the second stage, that is taking the consultation of decision. So what is the court has the only duty, as explained by the court, at the second stage, that is taking the decision after the consultation. So if the court intervenes or step in at the second stage, that is taking the due procedure, following the due procedure, taking the proper consultation of the people, the stakeholders, at the decision making stage, if the court intervenes, then it is a permissible intervention. But in our case, as your lordship explained, whereas the intervention is, the court is intervening at the third stage, that is the execution stage of the policy, where the court has no jurisdiction to tell whether the policy should be executed or not. It should only see whether the policy is, whether the decision is taken after the consultation, and it should ensure that while implementing the project, no rights or no laws will be violated. As your lordship asked, say that why can a court direct to execute a project proposed by the government? In the case of Balco Employees Union of India, court held that evaluating the merits of the any project or economic policy and directing.
Can you tell me, in previous case that you are challenging, the case of the matter that was listed in High Court, the PIL, were you the party in that case?
Lordship, in the PIL?
Yes.
In the first PL, which is filed at the...
In High Court.
Your lordship, stakeholders were there, but it was not led by the Govindas, your lordship.
So why didn't you join that case? Why didn't you raise all your objections in High Court?
Your lordship, we already raised the voice against these allegations, this demolition directly under Article 32 before the Supreme Court, your lordship.
But when you have the alternative remedy under Article 226, so why you are coming to the High Court?
Your lordship, there was a grave violation of fundamental rights, and Article 32 is itself is a fundamental right, your lordship. Approaching the Supreme Court through the Article 32 itself is the fundamental right, and denying that right, proposing that there was an alternative, will be again the violation of fundamental right, your lordship.
Do you not think that the PIL has been filed in High Court only, so it should be the right jurisdiction to consider this issue?
Your lordship, the issues were having connected deeply connected with the religious matters, and lakhs of pilgrims all over the India who are devotees of the temple were concerned. So it was filed before the Supreme Court, your lordship.
Do you know what is impediment?
Your lordship,
do you know what is impediment? Impediment
means ignorance, your lordship.
To join as a party in any case, as a third party, if your rights are being violated. So when this case was was going to be discussed in High Court in PIL, so why didn't you impede as a party? Because your rights were being violated, as you are saying right now.
Your lordship, this case before the High Court only filed after the stampede, your lordship. It was only requested the judicial intervention, your lordship. But in Supreme Court, it's concerned about all the rights, all the stakeholders' rights, your lordship.
Okay, proceed.
In the case of Balco Employees Union versus Union of India, the court held that evaluating the merits of economic policies is not a role of judiciary, as the infrastructure policies like building corridor highly connected with tourism, employment, transportation, and investment. So in this case, it was held that in economic policy matters, a court cannot intervene. So to apply this principle, first we have to see whether this infrastructure project is a economic policy or not.
Sorry to interrupt you, but your 10 minutes are over. You may continue, but your 10 minutes are over. Thank you.
Your lordship, I'll request you to extend the time, your lordship.
Okay. Got it.
Second issue. So, in concerning the issue 1, whether the as in the Narmada case and Asif Mohammed was a state of Jammu Kashmir, it was held that the High Court intervention at the stage of execution or the policy making will be impermissible micromanagement. That the contention of the petitioner is that court should have intervened at the second stage, that is with taking the decision without the consultation, as it violates Article 14 and amounts to arbitrariness. Court should have intervened at that stage, that is decision making stage. If high court intervened at that stage, then it would have been the valid intervention. But the court action of directing the state government to implement the project which is proposed, which is the impermissible judicial overreach, and it is a impermissible micromanagement of execution policy, Your Lordship. Then council seeks permission to move on to the second issue, Your Lordship. Whether the reconfiguration of temple approaches and religious circulation routes implicates Article 25, 26, and if so, the correct is to distinguish faithful facilitation from unconstitutional interference. So, to understand this issue, first we have to deliberate upon what is the religion to India, what is the Hinduism to India. Swami Vivekananda explained Hinduism is not about only scriptures, not about only doctrines. It includes the experience, practice, rituals, and wisdom. So we should be clear when we talk about the Hinduism and religion in India that it is not only about the rituals, it is not only about the doctrines, but it also includes the rituals and the practices which are done in the pursuance of religion. So in the preamble of the Constitution, our nation embraces secularism, not in a negative sense, but it ensures that all individuals get the freedom to practice. We have to emphasize on the word that is practice, profess, and propagate their faith. Article 25 and 26 confer this freedom on the citizens, that is right to religion. Article 25 guarantees that without any intervention, are equally entitled to freedom of conscience, right to free profess, practice, and propagate religion. Article 26b confers every individual denomination that freedom to manage its own matters of affairs. So, to deliberate upon the issue, we should concentrate that what is the valid intervention state in the religious matters, and what is the violation of Article 25 and 26. So to see that, the Ranjan Gogoi in the case, he explained what is the Hinduism and what it includes. He says that Hinduism is an eternal faith where there is no single scripture, no fixed set of teachings, but it has a time, antiquity, and tradition. So the Ranjan Gogoi emphasized on the Justice Ranjan Gogoi emphasized on the antiquity and tradition aspect of the religion, which says that Hindu religion is such a religion where the devotees have the connection with the time, antiquity, and the tradition. And when the state try to intervene and try to depart that tradition or depart from the antiquity, then they'll revolt against it. So in the case of SP Metal Union of India, it was held that
Mr. Counsel, can you please tell me Article 25 is absolute right or not?
No, Your Lordship, it's not absolute right. It is subject to the public order, morality, and health, Your Lordship.
So, do you not think in this case public order and health should be paramount?
Your Lordship, even though public safety and health are the paramount, but while ensuring that right, the state should ensuring that the right to religion is not violated. It should be forced in, Your Lordship.
No. See, the restrictions has been given under Article 25. There are three restrictions: public order, health, and morality. So
Yes,
here the state is using public order and health. So that is why your Article 25 is violating. So it is in permissible limits.
Your Lordship, even though state has the right to infringe Article 25 and 26 under the justification of public order and morality, but the court held in different decisions that while doing that infringement in the name of public morality and order, essential core principles of the religion should not be touched. That is the principle, Your Lordship.
Yes, now you came to the point. So what are those judgments? Can you please tell me?
Indeed, Your Lordship. In the case of SP Mittal versus Union of India, the court held that state must refrain from interference unless the practice is shown that it is essential to religion. The court opinion is that until and unless certain practices are shown as essential to religion, the state should not interfere in such matters. In the case of Adi Shivacharya Galu,
now you just tell me one thing. Can you prove how walking through the same old lanes or routes is an essential part of worship?
Indeed, Your Lordship. So, to understand what is essential religious practice, the landmark case is Commissioner Hindu Religious Endowments Madras versus Sri Lakshmi Indra Tirtha Swami versus Shirur Mutt, famously known as Shirur Mutt case. So, in this case, your lordship, whenever we talk about the essential practice, that your lordship asked to prove that whether it is a part of essential practice or not. So whenever we talk about the essential religious test, the first question that comes is, who is the authority to decide what is the essence to the religion and what is not essential practice of the religion? In this case, in the Shirur case, the court held that not only the religion doctrines are the essential part of religion, but it extends to the rituals, ceremonies, observance, and even modes of dress and food. Even the minute details like dress and food constitute the essential parts of your religion, your lordship. And your answer to your question, that whether this walking through the going to darshan through the that preaching forms the essential part of religion or not, the court held that, affirmed that these constitutional protections under Article 25 and 26 not only extends to the religious opinion. I'll repeat it. The constitution protections not only extends to the religious opinion, but it also extends to the acts done in the pursuance of the religion. So acts done in the pursuance of religion. Your lordship, this act of going through the preaching way, preaching darshan, in that way to the darshan is also a act which is done in the pursuance of religion. So it is not only the mere road. It is mentioned in the purport that it is not a normal road, but it is the road which have other temples, religious institution which are century old. So there will be a traditions like first visiting the one temple, and after visiting the main temple, there will be traditions like this. So to answering your question, in the Shirur case, it was held that it is not only doctrines, it is also acts done in the pursuance of religion. So not only worshipping the god, but also the acts which are done in the pursuance of that main act of worship. So this act of going to the darshan through the sacred valleys falls under the definition of acts done in the pursuance of religion, thus constitute the essential part of religion, your lordship. Again, we talked about the question, who is the authority to decide what is the essential part to religion and what is not. In the case of Sheshamal and others was a state of Tamil Nadu, court held that once a practice is integrated to religion, it should not be touched by the state. And it is further held that the authority which will decide what is the essential practice to the religion is not the state, but it is the community or it is the believers of the religion who is the authority to decide what is the essential part of the religion. Because the state or the judiciary, these organs are secular organs, but it is the authority of the religions or the believers to decide what they believe to be essential to the religion. So in this court itself held that people or the believers or the religion that follows, they are the authority to decide what is the essential part of the religion. So as I established in the previous case, the going through that darshan, going to the darshan to the through the sacred valleys is the act done in the pursuance of religion. And as the authority, we believers or religious followers, we are the authority to decide what is essential part of a religion, your lordship. So in the case of Ratilal Pranchand Gandhi was a state of Bombay, the court.
But do you not think this is the only way to control the crowd?
Your lordship,
This is
there
the
are other.
this is the subject matter of a state to manage the crowd or to prevent the stampede that has happened previously.
Your lordship,
Does it not directly affect the right of the devotees?
your lordship, in Prapo itself is mentioned that what is the reason for the tragic stampede. It is mentioned that insufficient personnel for crowd control, physical disturbance, that is called, your lordship. So it is the failure of the state to manage the crowd, your lordship, and the lack of personnel appointed there, your lordship. And the second point
Is it
Sorry
mentioned
to
in the mood
interrupt you.
position or not?
it is mentioned, your lordship.
Okay.
Lack of regulated entry and exit points, insufficient
Sorry to interrupt you, but the your time is up. I would request you please give chance to another speaker also.
Your lordship, as your lordship posed the question about the alternatives, what are the alternatives were there and why it is not implemented, and the examples of other temples where court held that such alternatives should be followed, that issues will be dealt by my second speaker, council.
Now I would request petitioner 2 to please start with the proceedings.
The council seeks permission to deal with issue 3 and 4, your lordships.
My lordship, please allow her to speak.
Yes, please complete. Start.
Indeed, your lordship. Issue 3 deals with whether the state's objectives of crowd management and public safety under Article 21 justify the large-scale demolition and redesign of an originally evolved sacred precinct when less restrictive alternative measures were available. Your Lordship, the Banke Bihari temple is originally evolved heritage precinct with immense religious and historical significance. The large-scale demolition and redesign of such sacred and naturally developed precinct was neither necessary nor justifiable. I would like to present my arguments in four folds. The first fold is that here the tragic incident which took place on August 19, 2022 was a direct consequence of the systematic failure of the state in regulating the crowd and maintaining the entry and exit points and providing other facilities which is to maintain the public safety. Firstly is that the state is not taking the blame on itself because it was the fundamental duty of the state to provide protection to the devotees who enter the public spaces. Initially, it is mentioned in the proposal that prior to 2022, before the stampede took place, the state government had not even provided any measures to maintain the crowd in the temple. Banke Bihari temple, as provided in an article of Times of India dated August 7, 2025, showed the statistics that the temple received devotees of around 50,000 per day and around weekend lakhs and above, your lordship. When such being the statistics, it was the bounden duty of the government to provide safety measures, less restrictive safety measures to protect the devotees there.
That is why state or the government, state government, is going to implement this corridor plan just to prevent these kind of incidents.
Indeed, your lordship. I would like to quote a case for you is that in Narmada Bachao Andolan versus Union of India, the Supreme Court held that large-scale projects which have ecological and social impact is permissible only when less restrictive alternative measures are available. But in this case, when we filed a petition, PIL, before the High Court, we prayed for a less restrictive alternative measures because, as I mentioned, priorly to 2022, the government had not performed their duty, which was ignored by the state.
So now the state is performing its duty to make a corridor plan. So why are you objecting?
Indeed, your lordship. Like I mentioned in Narmada Bachao Andolan, less restrictive measures are available. Without fulfilling them, going for a large-scale project.
Do you really think that to control lakhs of people, there should be some alternative measures, or there should be
Indeed,
a big
your
plan?
lordship. Indeed, your lordship.
How will the alternative measures can control such overcrowded place?
Indeed, your lordship. I would like to quote certain cases.
And if due to lack of any mismanagement, if such incidents will happen again, who will be the responsible for it? Do you not think the lives of the devotees should be paramount?
Indeed, your lordship. I would like to quote certain cases where the Supreme Court has held that both could be maintained, your lordship. Firstly, in Travancore Devasthanam Board Employees Front versus State of Kerala, which is known as Sabarimala Virtual Queue System case. In this particular case, there was a stampede which took place in 2011, as a result of which the Kerala police opted for a virtual queue system. Under this, the devotees are let into the temple on a time basis. They are regulated through an app of the government itself, so that they are allotted into the temple and allow a regulated darshan to the devotees. And in another case, TDD Employees Association versus State of AP, here the court ensured that orderly darshan is an essential part of managing the crowd. And another case is P. Venkateshwaralu versus Executive Officer Tirumala Tirupati Devasthanam. Here, in this particular case, the time slot darshan was challenged by the petitioners. Here again, the Supreme Court said that the time slot darshan did not violate Article 25 as the devotees could not demand darshan at any particular time, but they will be let in and have their darshan in an orderly manner, which should be paramount to protect the lakhs of lives. I would like to move on to my third fold argument, which states that the proposed redesign and organically evolved sacred precinct, it also contravenes with the Ancient Monuments and Archaeological Sites and Remains Act. Under this, it was the bound, like I mentioned, it was the bounden duty of the state to protect the monuments under Article 49 of the Constitution, which imposes an obligation on the state to protect the monuments, places, and objects of artistic or historic interest. When we look into the core objective of the act, it is to preserve ancient and historical monuments and sites, Your Lordship. And Section 2A of the act defines what ancient monument is. It includes any structure of historical, archaeological, or artistic interest which has existed for not less than 100 years. Here, the Banke Bihari temple also satisfies the prerequisites. Firstly, is that it has existed for more than 100 years, which is nearly 160 plus years of age, and secondly, having sacred value and artistic value. Thus, the state needs to give protection to the particular temple. And moving on to my fourth fold argument, it is in State of Odisha versus Arnendu Kumar Das, the Supreme Court clarified that the scope of construction within prohibited regulated zones of the Jagannath temple, holding that no work can proceed without due process and statutory permissions, by pairing to the High Court ordering permitting construction near the Banke Bihari temple without the authorities' permission is violative of the act. And the onus or the burden of proof lies on the state for not furnishing any proof that it has sought the statutory permission, nor before the High Court, nor right now. I would like to move on to my fourth issue, Your Lordship.
Yes, please proceed.
Indeed, Your Lordship. Fourth issue deals with whether the absence or inadequacy of meaningful public consultation of the stakeholders renders the decision-making process arbitrary under Article 14. Your Lordship, Article 14 of the Constitution declares that the state shall not deny any person equality before law or equal protection of law within the territory of India. This means that the Article 14 does not only extend to inequality or discrimination, but it also extends to actions of the state which are arbitrary, unreasonable, and unfair in nature. I would like to refer to the case where E.P. Royappa versus State of Tamil Nadu. In this particular case, the E.P. Royappa, who was the petitioner, his rank was reduced without providing any particular reason. It could be any legislative or executive action which is not providing any reason or rational cause for that act is arbitrary in nature. While drawing nexus to our case, the touchstone of asserting executive action under
Sorry
Article
to
14...
interrupt you, but your 10 minutes are over.
Your Lordship, please extend my time for...
If Lordship wants to extend the time, then it's absolutely fine, boss.
Okay, repeat it fast in 1 minute.
Indeed, Your Lordship. Here, the state action to consult the stakeholders and wait for the objections to be raised was indeed not followed. And then the principle of fairness was laid on in the landmark case of Maneka Gandhi versus Union of India. In this particular case, how it amounts to arbitrariness is that the failure of the authorities to conduct meaningful consultation.
Just answer by one question and you will become.
Indeed, Your Lordship.
Do you have any case or judgment in which the court ruled that public consultation is mandatory for infrastructure projects or policy decisions?
Indeed, Your Lordship. Under Section 5 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act of 2013. Initially, the act before this did not include mandatory public participation and consultation. Hence, after an amendment in 2013, the act included Section 5 that obligates the state to conduct a public hearing in affected area to ascertain the views of the affected families and to incorporate such views in the social impact assessment. Now, social impact assessment includes the grievances of the people. Now, one such case where the court held was in Union of India versus Shivraj, the court held that SIA is not a mere formality but a substantive safeguard to ensure transparency and participatory decision making. And also in Bajirao Tot versus State of Maharashtra, the court held that SIA is a mandatory requirement but not a procedural nicety. Without acquisition, without it is void ab initio. In this particular case, also the failure to conduct the SIA were also amounts to arbitrariness under Article 14. One
So
last
do you not think it is the matter of urgency due to the deaths of people? So many people have been died in 2022 stampede. Do you not think it is the matter of urgency? So it should justify limited public consultation.
Indeed, Your Lordship. In AP Pollution Control Board versus Professor M.V. Naidu, the Supreme Court held that environmental safeguards such as environmental impact assessment cannot be bypassed even in urgent matters, Your Lordship. Nor could environmental impact assessment and SIA go hand in hand, and hence they cannot be bypassed even in urgent matters. Indeed, Your Lordship. In another case, Satellite Industries versus Union of India, the court quashed the project approvals on the ground that mandatory EIAs were ignored. And in this particular case, also, the government has not provided nor notified about the environmental impact assessment and sought any permission from the government. In conclusion, the absence of meaningful consultation with the affected families, the shopkeepers, religious institutions, coupled with the failure to comply with the statutory safeguards, renders the decision making process arbitrary. If your lordships are satisfied, I would like to move on to the prayer.
Yes, please.
Wherefore, in the lights of the facts stated, issues raised, arguments advanced, and authorities cited, the petitioners most humbly respectfully plead the Honorable Supreme Court to dismiss the writ of mandamus issued by the High Court directing a particular corridor scheme as it amounts to micromanagement of executive policy and violation of separation of powers. Secondly, to declare reconfiguration of the temple approaches as unconstitutional as it is violative of Article 25 and 26. Declare state decision to implement the project without proper consultation as arbitrary action. Fourthly, to direct the state to not execute the corridor project, which amounts to violation of Article 21, 25, 26, and 14, and follow other alternative measures available. And pass an order, direction, or relief that it may deem fit in the interest of justice, equity, and good conscience. And or pass any order that it deems fit in the interest of justice, equity, and good conscience. The parties shall accept the judgment of the court as final and binding for them and shall execute in its entirety and in good faith.
Now just answer my one question.
Indeed, Your Lordship.
You both of you are totally against the corridor project, or you are just saying that it lacks the due process of law?
Your Lordship, we are not completely opposing the project. We are saying that due process first, the alternatives that is proved. As our co-counsel explained that in the Narmada case, it is mentioned that when there is proved that there is a less restrictive alternatives measures are there, large scale projects, infrastructure project like this should not take place, and alternatives should be followed. So following that ruling, our request is that that alternative should be followed and proper consultation should be taken, Your Lordship.
If the proper consultation or all the mandates should be followed, so you are in favor of the corridor project.
Your Lordship, if it not violates our Article 25 and 26 and it will not demolish the religious institutions that are in way, and it proposed a corridor project not in this valley but is another valley where it is a normal road, then it would be acceptable, Your Lordship.
Sorry to interrupt, but
I got your point.
sorry to interrupt, Lordship, but I would request the respondent team to please let them speak. Their time is up.
Yes, please. Respondents may start their.
Thank you, petitioners, for your argument.
Am I audible to you, Your Lordship?
Yes.
Much obliged, sir. The council seeks permission to address the bench collectively as Your Lordship. The council is here in the matter of Govind Das and others versus the state of Uttar Pradesh and others. On behalf of respondent, that is, state of Uttar Pradesh and others, Your Lordship, I would be dealing with the issue number 1 and 2, and my co-counsel will be dealing with the issue number 3 and 4. If the bench is well versed with the fact of the cases, the council seeks permission to proceed with the issue number 1.
Yes, please proceed.
Much obliged, Your Lordship. Your Lordship, the council on behalf of respondent respectfully submitted before this honorable court that the High Court mandamus under Article 226 is a constitutionally valid exercise of judicial review and does not amount to impermissible micromanagement. Court in India have consistently recognized that where executive inactions or systematic failure jeopardize fundamental right, particularly the right to life under Article 21, court are empowered to issue affirmative directions. In a present case, the High Court acted within its jurisdiction to protect public safety after the tragic Baki Bihari temple stampede. Your Lordship, the submission proceed in 3 parts. The scope of Article 226 empower High Court to issue wide-ranging directions to enforce fundamental right. In second, the public safety and the right to life under Article 21 justify proactive judicial intervention. And in a third, the High Court power remedies proven executive inactions and does not amount to absorption of policy making. Your Lordship, in the para number 2, it is respectfully submitted that the Article 226 confer broad powers on High Court and mandamus lie where a public duty is clear. The council seeks permission to read the Article 226 clause 1, Your Lordship.
Yes, please.
Your Lordship, may I read this? Article 226 clause 1? Yes.
Basically, there is no need to read Article 226.
Indeed. Much obliged, Your Honor. This provision has been interpreted to give the High Court the widest and amplitude of remedies power. Article 226 explicitly grants High Court the power to issue mandamus for any other purpose beyond Part 3, which is fundamental rights. So the broad phrase was adopted to empower the court to remedy matters even if they are not purely fundamental issues, Your Lordship. The corridor case concerns fundamental right to life, but even if viewed as a policy measure, that any other purpose clause ensure the High Court may intervene when necessary. In Common Cause versus Union of India, the High Court has a jurisdiction under Article 226 to issue writs for protection of fundamental and legal right, including issuing mandamus to enforce public duties. The writ of mandamus is traditionally available to compel public authorities to perform mandatory duties. It is well settled in Indian jurisprudence. The mandamus lie not only to enforce ministerial act, but also when public welfare obligations are ignored. Your Lordship, here the state has constitutionally and statutory duty to provide conditions for the citizens. The corridor scheme was a planned solution. The court's order ensured that the duty is fulfilled. In Hari Krishna Mandir Trust versus the state of Uttar Pradesh, the Supreme Court held that the court are duty bound to issue mandamus to enforce statutory or public duties. Your Lordship, in case of Dwarka Nath versus ITU, the Supreme Court held that the Article 226 is designed to reach injustice wherever it is found, transcending technicalities. The writ of mandamus extend not only to prevent unlawful actions, but also compelling affirmative actions where the executive fails in the constitutional duties. Your Lordship, Article 21, though guarantees no person shall be deprived of his life or personal liberty except according to the procedure established by the law. The right to life under Article 21 is the most sacrosanct of fundamental rights, encompassing not only existing but also safety, dignity, and protections from unforeseeable risk. In Francis Corelli
Miss
Mullin
Council,
versus
Miss
yes, Your
Council,
Lordship.
I have one question. I have one question.
Yes, Your Lordship.
Just tell me this thing. If we talk about separations of power,
Yes,
so
Your
do you
Lordship.
not think to decide upon policy making, it should be the only subject matter of executive?
Your Lordship, the separation of power is a strict concept when we come to the countries like US or other foreign countries. But in India, the concept of separation of power under Article 50 is not a strict concept. It is a flexible concept, Your Lordship. So it includes the concept of check and balance, in which it is allowed that if there is any of the fundamental right violation, High Court has a power to intervene to the limited permission, Your Lordship. Okay, indeed, Your Lordship. The Baki Behari stampede of August 2022 exposed grave risk to pilgrims in life, invoking Article 21. The Allahabad High Court, in its March 2023 judgment, explicitly prioritized the preservation of human life over religious right. The corridor scheme was designed to elevate that danger. Judicial intervention to mandate corrective measures is thus a fulfillment of constitutional duty to safeguard lives. The court approach in consistence with PA Emadar versus State of Maharashtra, where the judiciary emphasized balancing competent right with primacy to Article 21. Moreover,
Miss
in
Council,
Mrinalini Padhi,
Miss Council, do you
yes,
not
sir.
think this order of High Court extend to binding the state to a single policy, that is corridor project, with
Your
no
Lordship,
flexibility? Like there should be other alternative measures to control the management of the temple. So if tomorrow public consultation shows a less destructive plan is possible, there are some other alternative measures. So are you still bound to this order? Do you not think this order binds you to just stick to a single policy?
Your Lordship, the High Court mandamus, the main issue is about the High Court mandamus was not issued in vacuum. It has taken all the things in a consideration with valid evidences. Your Lordship, the state proposed the corridor matter. On the other hand, the petitioner proposed the less restrictive measures. As it is shown in the Moot proposition, please provide the Moot proposition. Just a minute, Your Lordship. Sorry, Your Lordship, I'm not getting to able to get it. So, sir, in that state proposed that uh, a corridor should be made, but on the other hand, petitioner proposed that less restrictive measures can be taken. In that case, the state has done a multiple studies, and it is shown that in multiple studies that less restrictive measures cannot be fulfilled the requirement to make the corridor. Your Lordship, in that position, it is a very narrow lanes are there, and over 50 lakh pilgrims annually entered in that temple. So it can be said that the High Court does a evidence extension, including expert committee report on ground management, documentation of previous incidents, analysis of emergency response capabilities, comparative study of successful temple corridor, and less restrictive measures. And after all these measures taken, all these studies has been done by the High Court, then only this decision has been taken by the High Court.
Is it mentioned in the Moot proposition?
Yes, Your Lordship.
Can you please tell me?
Your Lordship, please refer to the statement of facts, para number 2nd, 6th line, Your Lordship. Despite multiple studies and administrative observation noting the area's vulnerability to congestion, comprehensive infrastructural change had not been implemented prior to this. So it has particularly written that multiple studies and administrative observation has been done.
Okay, I got it.
Indeed, Your Lordship. Your Lordship, I would like to refer to the issue number 2nd. Proceed for issue number 2nd. It is respectfully submitted that the reconfiguration
Sorry
of
to
temple.
interrupt you, but your 10 minutes are up. If you want to continue, then you can, as per the permission of
Okay. Your Lordship, may I take some
Please
extra
continue.
time? Much obliged, Your Lordship. It is
Very fast.
respectfully submitted that the reconfiguration of temple approaches, LA, and religious circulation route does not violate Article 25 and 26, but rather constitute faithful facilitations of devotees' constitutional right. The respondents submit that state regulation to ensure safety, order, and accessibility is a constitutionally permitted. Article 25 and 26 protect only essential religious practice, not every incidental activities. Judiciary evolved test distinguish facilitation from interference, and a state's action fall within permissible limits. The petitioners' concern regarding interference and heritage are misplaced, as the project enhance rather than diminish religious activity. Your Lordship, as per Article 21 of Constitution of India, subject to public order, morality, and health, and the other provisions of this part, all persons are equally entitled to freedom of conscience and the right to freely profess, practice, and propagate religion. Likewise, Article 26 safeguard religious denominations' right to manage their own affairs in a matter of religion, but again, it is a subject to law, public order, and morality, Your Lordship. It is respectfully submitted that this explicit limitation reflect the framer's intent that religion freedom is not absolute. The Constitution envisages that where religious practice conflict with consideration of safety, order, and public welfare, the state is constitutionally empowered to regulate such practices. The Supreme Court in Acharya Jagdishwarnand Avadhuta versus Commissioner of Police, Kolkata, upheld restriction on religious procession that endanger public order, clarifying that the right to practice religion does not override concerns of security and discipline in society. Your Lordship, similarly, in Ismail Faruqi versus Union of India, it was observed that the place of worship and their use are subject to public order and secular regulation, even if the core religious right is protected. The stampede at Baki Bihari temple demonstrated the urgent need for improved circulations route to safeguard life under Article 21. Regulation of LA in a public regulation of LA is a public order and safety measure well within the state's power, Your Lordship. Your Lordship, Supreme Court has consistently held only religious essential practices enjoy constitutional protection. The Commissioner Hindu Religious Endowment Madras versus Sri Lakshman Tirth Swamir of Shrurmut, which is also known as Shrurmut case, draw a distinction between matter of religion and a secular administration, holding only the former to be protected. The Supreme Court has clarified, though the essential religious practice test, which developed in a Durga Committee Ajmer versus Sayyid Hussain Ali case, restrict protection to those practices integral to the religion itself, excluding incidental or facilitated aspect, Your Lordship. Your Lordship,
Miss Counsel,
more inquiry.
Miss
Yes.
Counsel, do you have any judgment that proves that temple routes or alleys and temple entries are not part of essential religious management under Article 26 and are purely secular activity, as you are saying?
Your Lordship, I
Do
don't
you have
have
any
a particular.
judgment?
No, Your Lordship, not a particular judgment, but I have a particular answer for this question as well, Your Lordship.
Yes.
Even if it is considered as a religious practice, but state are not demolishing the main temple, even the routes are becoming more feasible to the public or devotees. Like the corridor involved is based on Kashi Vishwanath temple corridor, which says that the main temple, the main Garbha Grihi will not be changed. Only the nearest place will be changed in this corridor,
So,
which will not hamper this
but-
essential practice, even if it is considered, Your Lordship.
but it is the matter of Vrindavan. So I think every place in Vrindavan has a significance. It's different significance. Because if you talk about Banke Bihari temple, so there are two routes to approach Banke Bihari temple. So and both the routes are filled with many places that are, you know, have their own significance, religious significance, and many temples are situated between those roads. So do you think those temples and those places are not as sacred as Banke Bihari temple? So is Vrindavan only about Banke Bihari temple, not about other temples?
Your Lordship, as you
Sorry to
concerned
interrupt
about,
you,
is there any problem?
but I would request Lordship to please allow respondent number 2 to speak, as the time limit is exceeding.
Just
Please
1
answer
minute,
this
Your
question. Please answer this
Thank
question.
Okay, sure.
Thank you so much. Your Lordship, as the concerned rate is considerable, but it cannot be overtaken by the Article 21, which says that right to life is subservient to the right to religion. As it is said by the High Court judgment passed in a 2023 20th March judgment, that the court emphasized the protection of human life and public safety were paramount, and the heritage conservation must evolve with the need of the present. Your Lordship, though it is considered that it is a heritage and have a significance value, but it cannot be take over the life of the people just for that, Your Lordship.
Okay, I got it.
Now I would like respondent number 2 to
Am
please
I audible to
with
the
your
honorable
proceeding.
bench? Your Lordship, I will be dealing with the issue number 3 and 4 and seeks permission to proceed with the issue number 3. The
Yes,
issue
please
number
proceed.
3 is whether the state objective. Hello, am I audible?
Yes, you are audible. Please proceed.
The issue number 3 is that whether the state objective of crowd management and public safety under Article 21 justify that the large-scale demolition and redesign of an organically evolved sacred precinct when less restrictive alternatives like the staggered darshan, technical flow, festival time regulations may exist. Your Lordship, the respondent action is a proportionate response to a grave and the imminent threat to the right to life under Article 21, which outweigh all other consideration, that the fundamental right to life and the personal liberty under Article 21 is also encompassed to right to the safe environment and the protection from the foreseeable harm. Your Lordship, the stampede on August 19, 2022, which resulted in the death of 2 people and the injuries to the other people, demonstrated that there was an immediate threat and there was a requirement of the public safety and requires the urgent remedial action. Your Lordship, in the case of Bandhuha Morcha versus Union of India, just please wait a minute. Please close the windows. I'm sorry. Your Lordship, in the case of Bandhuha Morcha versus Union of India, please refer to the para number 36 of the Moot Memorial. My Lord, in this case, the Honorable Court has consistently held that right to life is the most fundamental of all the rights, and the state has a positive obligation to take a preventive measures against foreseeable threat to the life. And in the present case, the state response not only reasonable but constitutionally mandated to protect the life and also stop the further losses. Where there is a danger zone or
And in the Supreme Court, the Supreme Court in the case of MCD versus Association of the Victims of Apart Tragedy, which emphasized that the state's duty and the accountability. It was a case of the disaster happened in the theater. So here the court held that it is the state duty to prevent the further disaster in the public spaces, and all to criticize the public authority for failing to take a mandatory steps for the security of the people. Your Lordship, the second contention is that the alleged, I'm sorry. And Your Lordship, the second condition, that is the alleged less restrictive alternatives, which are inadequate to address the safety measures. Your Lordship, the suggested alternatives of staggered darshan, tech-enabled flow, and the festival time regulations have been thoroughly examined by the High Court too, and are found to be insufficient to address the fundamental structural deficiency in the current temple. The narrow lanes, the inadequate emergency access, and a complete absence of crowd management infrastructure create a systematic risk and cannot be addressed through the managerial solutions. And my lord, in the case of Municipal Corporation of Greater Mumbai versus Anita Singh, the court recognized that authority must have to take up proactive measures where infrastructure deficiency create a systematic risk and cannot be mitigated through the managerial adjustments alone.
Ms. Counsel, tell me one thing. The eviction of hundreds of people, the demolition of hundreds of people's home or businesses without proper rehabilitation, does it not violate Article 21? How do you justify evicting families and businesses for this project without first ensuring fair resettlement?
Your Honor, the Article 300A, which is not a fundamental right, it is a constitutional right, which provide whenever there is the state can take the property acquires for the public welfare or for the social welfare. Here, it is for the public safety, as there was a threat on the human's life or the public the life of the devotees. So it is the action. This is the duty of the state.
But my question is different. I'm saying, without fair resettlement of people, how can you evict someone?
My lord, actually that was the allegation, and even see the state has taken the all the measures for the rehabilitation, and the project was in initial stage. So there might be some minor technicalities or irregularities.
But petitioners are saying no public consultation has been done yet. So how can you say that fair rehabilitation process has been done?
My lord, I will answer this question particular in my issue number 4. Can I proceed with the next? I'll be deal with this answer with the next part. Okay.
Proceed.
Okay. My lord, the Allahabad High Court, after examining the expert report and the past incident report, conclusively found that the piecemeal solutions would be insufficient and the comprehensive redevelopment was necessary. My lord, in the case of Khimji Vai Harvansh Rai Patadia versus Municipal Corporation of Greater Mumbai, the court held that once a building is classified as the C1 category, that is...
Sorry to interrupt, but your 10 minutes are over. If Lordship allows, then you can continue with your proceedings.
Okay, the council seeks the permission to extend the time, my lord, please.
Okay, please complete it fast.
Much obliged, Your Honor. So, my lord, in the case of Khimji Vai Harivansh Patadia, the court held that once a building is classified as the C1 category, means the dangerous category, by the technical experts or committee reports, piecemeal repair cannot stand in lieu of the full redevelopment. The court deferred the structural expert finding and directed the redevelopment even where the tenant is okay. And that the technological solution and the crowd management techniques require a physical infrastructure to be effective, including the adequate space for the queue and emergency lanes and proper entry-exit points, which simply do not exist in the current precinct. And the state approach represents the only comprehensive solution that addresses the root cause, not the solution, not giving the remedy to the symptoms. And my lord, in the case of Surbi Bose, please refer to the page number 25, para 41, the 5th line, my lord. In Surbi Bose versus others versus Union of India, the Calcutta High Court found, the Calcutta High Court found that where a temple precinct's infrastructure, safety, hygiene, accessibility are in serious decline, comprehensive redevelopment involving demolition of stalls, relocation of vendors, road improvement, drainage, lighting, boundary gates, and the public amenities is required rather than mere patchwork of piecemeal fixes. The Kalighat scheme embodied precisely that full precinct redevelopment is
just okay. I got your point. Answer me one question.
Okay, sir.
Is public consultation has been done or not yet?
So the public consultation has been not done in this particular.
So do you not think it lacks due procedure of law?
Sir, it's a due process. Okay. So just give me 1 minute. My lord, please refer to the page number 29 of the Moot Memorial.
You can read it.
To interrupt, sir, but
Okay.
the time for respondent
Sir, in
number
this case,
is up.
sir, in this case, actually, while participatory governance and the transparency are desirable, Supreme Court has consistently held that the absence of public consultation does not ipso facto amount to the arbitrariness under Article 14. The court recognized that the executive and administrative decisions involving policy and development projects may not require the exhaustive consultation.
My
And there is
lordship,
one
am I
case
audible?
given.
I
Yes,
got
sir.
your answer. I got your answer.
My
Okay,
lordship,
sir.
am I audible?
Yes, I am audible.
Yes, sir.
Yes, you are audible.
Actually, for the time for respondent number 2 is up. We have to start our next round, which is Revit. And it's for 5 minutes only.
Okay. Please start the rebuttal.
Thanks.
Okay.
Now I would like petitioner number 1 to start with their proceedings for rebuttal. Any one of them can speak.
Your Lordship, while the Lordship posed the question about the social impactment or environment impact assessment, they referred to the para number 2 of the propo and they told that despite multiple studies and administrative observation, noting the area's vulnerability to congestion and comprehensive infrastructure changes. Your Lordship, in propo, it's only mentioned the reports and studies have only taken about the congestion or the vulnerability of that Alice, Your Lordship, but the no report or the no assessment, no public hearing are taken about the social impactment assessment, which is mandatory under section 4 of the right to fair right to fair compensation and the social impactment study, your Lordship. While
So
the social impactment,
it means you want to say there are no social impact assessment has been done that can show that alternative measures could be taken.
yeah, indeed, your Lordship. In propo, they mentioned to the propo, but in this line, they only mentioned about the vulnerability of the conservation. They nowhere propo they have mentioned that the environment and assessment have taken. And according to the section 3 and the notification of 1999 of the environment impact assessment notification, it is compulsory to do that environment assessment and to publish it in the official gazette, your Lordship. So no such study has taken place, no such mention in the propo. So it is the violation of Environment Protection Act Section 3 and Social Impactment Assessment under right to fair compensation, your Lordship.
Am I audible?
Now respondents, yes, please. Respondents can proceed with.
The council seeks to answer this question, my lord. Actually, as they have mentioned about the Ancient Monument Act, my lord, that the Banki Bihari temple, though it is being the antique, the 100-century-old temple, and also of the historical significance, but it does not fall under the category of the ancient or the archaeological site. And my lord, and it is not notified by the government, by the central government. And if it is not notified, it will not get the legal protection of this act, of the Ancient Monument and the Archaeological Act of 2003. That's all my question. And my lord, I want to ask the question. My lord, as my opposite counsel seeks the reach to the Supreme Court under Article 32, which is a writ petition. My lord, a writ petition cannot be filed against a writ petition, though they first moved to the writ petition under 226 to the Allahabad High Court, and then after they are coming to the under Article 132, which is also writ petition. A writ petition cannot be filed against a writ petition because it is barred by the res judicata.
But I think in this case, SLP has been filed, not a writ
Yes, my
petition.
lord. And the opposite counsel goes to the Supreme Court under Article 32. It is not come under.
When the SLP has been filed, so how he can go to the Supreme Court under Article 32?
My lord, the opposite counsel, that is the petitioner side, go to the Supreme Court under Article 32. Please read their memorials. They had taken the jurisdiction under Article 32 of the Constitution.
Okay, in their jurisdiction.
Yes, my lord.
Statement of jurisdiction. Okay.
Yes.
But in moot proposition, it is written under Article 136, petitioners have approached.
No, of the petitioner, it is written 32. We are from the respondent side, and our opposite counsel, that is the petitioner side, they take the jurisdiction of the Article 32 of the Supreme Court. And a writ petition cannot be filed against a writ petition because it is barred by the res judicata.
I got you.
Your Lordship, counsel seeks to answer this in a brief, Your Lordship.
I think rebuttal round has been completed.
Yeah, in Lordships?
Is sir rebuttal allowed or not? Archit?
Your Lordship, only few seconds.
Archit?
Yes, sir.
Are you here?
Yes, sir. Yes, sir. I'm here.
I was asking, sir rebuttal round is allowed or not?
Sir, it is allowed, but it is for 5 minutes. Not more than.
Sir rebuttal. No, I'm talking about sir rebuttal, not rebuttal.
Yes, yes, it is allowed, but it is for 5 minutes. Not more than 5 minutes.
Yes, please complete it. Complete it first.
Your Lordship, their contention was that petitioner should go in special petition and not in Article 32, but it is given in the parties involved in the propo itself that Govindas, on behalf of the hundreds of similar affected residents, humbly approaches this Honorable High Court under Article 32, Your Lordship. And in the case of Kapai others versus Large and Public Charitable Trust, it was held that when the same question or same cause is involved, both the special petition and Article 32 can be clubbed. This was held in this case, Your Lordship. And
in moot proposition, it is particularly mentioned that petitioner has approached Supreme Court under Article 136.
Indeed, Your Lordship, but in para 1, when it is mentioned in the parties involved heading, in the proposition itself, it is also mentioned that the humble approaches this honorable court under Article 32 of the Constitution India seeking redress, Your Lordship. Please refer to the parties involved, para number 1 and line 15, Your Lordship. Your Lordship, you're not audible.
Please let me see.
Indeed, Your Lordship. And they mentioned about the present monument is not falls under these protected monuments as it is not published in the official gazette, Your Lordship. In the case of Rajiv Mankatoria was a secretary to the president of secretary to the president, the Supreme Court held that even though certain monuments which are not mentioned, which are not published in the official gazette, in para number 5 and 6, it is mentioned that even though it is not mentioned, some monuments shall be declared as protected monuments which fulfill the requisites like 100 years. It should be 100 years old, religious importance and artistic importance. When it has, it is enough, and it will be fulfill the requirements. It is eligible. So it is the main part in para number 5 and 6 of the judgment. It is mentioned that thus so such protected, thus ancient monuments which are 100 years old, which have the historical significance and artistic importance, even though it is not officially published, officially not announced as a protected monuments, it falls under the protected monuments category, and it should get all the sections or the protections that are under the which are mentioned under the act. Such protection should be provided to that monuments, your lordship. In this case, Rashtrapati Bhavan was
answer one question. Answer one question. You
Indeed, your
approach
lordship.
Supreme Court under Article 32, and yes, you are right that it is written in moot proposition. It is
Indeed, your
para number 1. I have read it.
Indeed, your lordship.
But in some of para, it is also written petitioner has approached Supreme Court with the SLP under Article 136.
Indeed, your lordship.
So I think it contradicts.
Indeed, your lordship, but both the approaches are contradicts. But in the case of Karam Kapai versus Lalchand Public Charitable Trust,
but more thing, you are here to challenge High Court's order. So how can you
Indeed,
challenge the
your
High Court order under Article 32?
Sorry to interrupt, sir, but the time for the competition is up.
your lordship, under
You can answer
petitions
this.
like search for
Your okay, don't worry, your time is up now. So yes, please, Archit, what you are saying?
Yes, sir. Sir, I would request you to please provide us the feedback to the speakers.
I think the speakers of both the team are very good. They are confident, and I'll say you must consider your arguments properly. What you are saying, like speaker 1 of petitioner, I'm really impressed from you. You have really satisfy all my questions, all my doubts, and speaker 2 is also good. And if I talk about respondents are also good, but try to give the answers of the questions, whatever the judges are asking you. So do not only stick to your arguments. What you are saying, don't think like you are saying that is only correct. What the judges wants to listen you, just answer those questions. So I'll say speaker 1 of respondent were also uh, were also good to give my answers, and speaker 2 were also good. So yeah, all the best for both of you. It was nice judging both of your teams.
Thank you so much, sir, for your valuable feedback. Now, I would request all the speakers to please leave the meeting.